Welcome back to another episode of My Legal Crunch. It's the place where you can get information pertaining to family law in Australia. I'm your host today, J. Richard Jones, and it's a pleasure to be with you. Today, we're going to be talking about one of the most important court events prior to trial. It's the way that both parties get ready for trial. What are we talking about? We're talking about a readiness hearing, and we're going to explore what is its purpose and what it all means. And today, to explain that to us, I'm very pleased to welcome our guest, Mr. Michael Rodriguez. He's a family law lawyer with experience across Australia nationwide, and he's here to talk to us about these topics. Welcome to the show, Michael.
Thank you for having me, John.
So, we're talking about a readiness hearing, and this, as I understand it, generally, it's an opportunity for both parties in a dispute to ensure that their cases are ready for trial. Why is it the most important part, Mike?
Yeah, thank you, John. In the new court system that we've had since 2021, they've made major changes, and so it's really the first event in which parties are actually before a judge in Division 2. So there are two divisions of the family court, and it's a really important event from the sense of the parties need to do some kind of exploratory work prior to that hearing to kind of understand what are their witnesses that they intend to call for trial, how long might they be at trial. And so there's a compliance readiness document that gets submitted, and that helps the judge, because you will see a judge on the day, decide whether the matter is ready to proceed to a trial. But there's a little bit more behind that, and I think it's a very popular topic that we get a lot of inquiries about. How do I prepare for one? What do I do? What are the things I need to think about? And so that's perhaps what we can discuss today that might help the public in general.
Now, just to be clear, is this an opportunity to negotiate at that point when you get together for one of these hearings?
Well, negotiation's ongoing, and it really should be done prior to that point anyways. And I would encourage all parties to not be afraid to pick up the phone and have a discussion with the other party, subject to if there's family violence orders in place. But really, the parties shouldn't be waiting till that point to discuss. In fact, a lot of the directions prior to the or leading up to the compliance readiness will say the parties are to put together kind of on paper what the issues are outstanding and try to figure out where they agree. So you can really present a coherent kind of list of, okay, to the judge, here are the points that the parties need determination at trial. And if you're not in the court space and maybe you're self-represented, this is probably one of the best events for you to kind of reality test yourself, whether you're prepared to continue down the path of self-representing, or if this is a really good point for you to get some advice from a lawyer, and then from there perhaps have a lawyer assist you, because the events after the compliance readiness, they really escalate towards the preparation of trial and a trial, and so they become increasingly more complex.
Mike, that's a great overview. For somebody attending a hearing of this type for the first time, can you walk us through like what happens in the readiness hearing? What's a day in the life like for that?
Sure. So you'll have a date and a time to attend the court physically. The best thing to do for parties is to think about their ability to get to court, whether there's any mobility issues or family violence issues. If there are, you should raise those with the court ahead of time, and there's appropriate ways to do that. You never write to the court directly. You would write perhaps to an associate or a case manager, and you do that with the consent of the other parties. But normally all those things will be noted well and truly in advance. If there is family violence concerns, the court can accommodate parties. Sometimes they'll create electronic links so for that party not to physically be there. Moving on, though, when you do attend the court, you should arrive a little bit early. If you don't have a lawyer, it might be the opportunity for you to seek a duty lawyer or a legal aid lawyer that's available to assist you and help you on the day. So the matters themselves, they typically don't go for too long, so perhaps 10 to 15 minutes, maybe maximum. It depends on how many parties you have involved. So if it's just you and the other party, it'll be a lot quicker than if you have, let's say, you, another party, maybe an independent children's lawyer, or perhaps a third party in the matter. And so your documents are being relied on by the court, so it's a compliance readiness hearing document that you're going to file ahead of time that will outline to the court how many witnesses you intend to call, who they are, how long you think the trial might run for. If you're self-represented and you don't have an idea of how long a trial might run for, perhaps you might be able to get an indication from maybe the other party if they're legally represented, or you could always kind of approximate. It's not uncommon to see people put a range in maybe 2 to 3 days rather than just 2 days. And then you need to think about your witnesses that you're going to call. What's the purpose of calling them? What evidence is it that they would be able to assist with? Now, if there is any family violence allegations, it's appropriate to request what's called 102NA funding. And so even if you have a lawyer or a duty lawyer, the court needs to be aware of that. And the reason for it really is that if at some point in the future, coming up to the trial, you lose your legal representation, it's not appropriate for a party who's has allegations of family violence to then cross-examine the person in which there's allegations that they have against them, or vice versa. And so the court will make use of that funding, and the 102NA funding allows for a lawyer to step in and to run the trial for that party. But 102NA funding is limited in some sense. It's not really there to run your case. But back to the hearing on the day itself, what you should try to do is see if you can speak with the parties ahead of time before going in, and that might not be on the day that you're there. It might be that you speak with the parties a week in advance, and you might outline in an email or in a letter kind of the issues that you think are outstanding. And that's really what you're trying to tell the court on the day in a very clear and concise way. What are the issues that are determined or that need to be determined for trial? And what are the witnesses that are going to be called? And you should also have an indication of when the witnesses might be available. So for instance, if we're talking a psychologist or someone of a medical background, you might want to contact their office ahead of time and say, can you give me an indication of, let's say, in the next 12 months, any dates in which you know that you're not available? And oftentimes when when you go to the compliance readiness hearing, they set you down for a trial, the trial won't be in a month's time or 2 months' time. Oftentimes the court will talk to you about a trial perhaps in a year's time or 12 months' time. Just really depends on the availability of the court. But it's helpful if you can say to the court, yes, I intend to call this particular witness, and I know that their availability is that they're available on all days except for, and then you can lay that out. Sometimes it's not possible to know that, but it does assist the court. And then just be really clear on why you're calling people if you're having them in the matter for evidence. What's the value? What are they going to say? How are they going to help the case? And I suppose it depends on whether it's a property or a parenting matter as well.
In terms of preparation, you've given some great points there. How does it work, though, for notification for people to be advised that they're going to be doing it? What type of documents have to be disclosed? How much lead time do they get? Is it just 1 week, or is it longer than that?
So the court assumes that when you get to that event, when you get to the compliance readiness hearing, there'll be a document and you'll have a deadline to file that document. So basically a court order will tell you when you're meant to show up for the compliance readiness, and it'll tell you when you're meant to file documents prior to. And one of those documents, or one of the things that you're meant to do, is give an indication that you've provided all the disclosure that you might need to provide. So in disclosure of property matters, that might be bank account statements, all the usual stuff that you're required to disclose. But in a parenting matter, that might be something a little bit different, which people don't necessarily think about. So it might be that you've disclosed any, prevalent medical reports related to the child, anything maybe that relates to school attendances. So parties have a duty under Rule 605 to disclose things for children, and so that's part of the disclosure obligations. Again, think about the compliance readiness hearing as it's the first hearing in which you're really before a judge in terms of the usual course of the way matters run. And it's the first time that a judge is looking at this, and they're looking at it in a way kind of as a summary. Where's the matter at? Is it ready for a trial? Who might we be calling for witnesses? How long might the trial run for? And what are the primary issues that the parties need determination on? And that's why, John, taking you back to a point you asked earlier, when should the parties start to communicate, or when should they start to look at trying to resolve issues? They have an obligation really to do that throughout the entire process, and oftentimes people wait till the last minute. So what I would encourage anybody listening to this to do is to really sit down and think about what the primary issues are. What really do you need the court's help with? And the things that are kind of perhaps things that you might be able to resolve with the other party, that's where you need to really either pick up the phone and call the other party or write an email, and you might have some discussions. You could have what's called without prejudice discussions. And so you could invite, if you're self-represented and the other side has a lawyer, you could invite that lawyer to have a conversation with you without prejudice conversation. What that basically means is you're having a discussion essentially off the record that might help you guys work through some issues. And those conversations aren't to come back into an affidavit or to be used against the other party, but really it's for you to try and assess with the other party, that issue that might not be so difficult to resolve. Is there something that you could do to solve it? Maybe going to counseling, or perhaps maybe there needs to be a discussion about what that issue is. And a lot of times parties can self-resolve these things. There's nothing stopping the parties while they're waiting through the court process to look at other services like mediation. You don't have to be ordered to go to mediation to do mediation in a court matter. There are some parties that will go to family therapy, or they'll get a psychologist involved, or they'll do there's other resources you can rely on. So I would encourage people because by the time you get to a compliance readiness, you're not before the court for a couple months. You're before the court for quite some time. It might even be half a year or a year. So in that time period, people really need to think about their case theory. What is it that I'm actually arguing about here? Or what is it that we don't agree on? And what is it that's left in dispute? And can we resolve this? And I think the biggest thing is, particularly for people who are self-represented, is they kind of don't do anything, and they just don't realize that they should be working on it. It's kind of like, imagine you're working on a puzzle piece, right? You're not going to solve a puzzle if it has 10,000 pieces in, half an hour. It's going to take some time. And that's kind of what a case is like for court. You should be working on the puzzle and trying to solve as much of it as you can, so that when you truly need to go to a trial, it's only on really discrete issues. And if you do that, you will save yourself a ton of money, because you're asking the court for assistance on a narrow scope of issues rather than a broad scope of issues. And so I think the takeaway for people is, yes, compliance readiness is an important event for the court, but really you should be looking at running your matter ahead of time. And there's nothing wrong, and this is another tool that people can think about, nothing wrong with hiring a lawyer on a limited scope retainer. Say, look, I've got a matter. I don't necessarily think I have the money perhaps for you to run the matter from start to finish, but here's kind of what the matter's about. How much would it cost for you to look at that and give me some strategies on how I can better manage this and prepare strategically, so that I don't end up at a compliance readiness hearing heading towards a trial where there's a lot of issues I could have self-resolved. I know it's a bit lengthy, but I think that should help the readers understand kind of there's a lot of preparation that needs to be done, and it isn't being done by a lot of people.
Well, certainly trial is probably the last resort that anybody wants, and there's some very significant steps here that you've outlined, and very much appreciate you breaking it down for our listenership and readership. Michael, this is an excellent article that you've put. Where can our listenership find it if they want to read more?
Yeah, certainly. If they go to mylegalcrunch.com.au, under the website, there'll be a section called the Knowledge Center, and then there's an area called Legal Blogs, and there's a ton of articles there on various topics, various different areas of law, that we put together to help the public or to give them some better understanding of different concepts. And I mean, those articles are there to give you a general guide. Obviously, if you've got a unique, everybody's case is going to be unique, so you'll need to probably speak to a lawyer at some point. But it'll get you and then get people that are reading the articles thinking about some of these things, and then they can always call us or call a lawyer and then try and get some help from there. And as I said, the public doesn't necessarily have to, in all circumstances, have a lawyer that runs the matter from start to finish. They can hire a lawyer for, discrete pieces of advice on certain areas or for strategy. And I often say to a lot of people that strategy is half of the law. Like, you have to figure out what is it you're really trying to achieve, how are you going to get there? And if you have a good strategy, I think you can save a lot of money in legal fees. When you don't have a strategy, oftentimes that's where you see people embark on a very costly exercise of doing things that perhaps don't get them to the outcome that they want. And in order to know that, the client or the person really has to ask themselves, what is it they're trying to achieve? and what's in the best interest of the child or the property matter or whatever it might be, and they need to know that. And that's something that you need to put some time into. Your lawyer can help you with that as well.
You've been listening to My Legal Crunch Radio. Our special guest joining us today, Michael Rodriguez, is a law and practice director for My Legal Crunch. We've covered a lot. We've talked about the topic of what is a readiness hearing, and we've talked about its purpose and so much more. Michael, thank you very much for joining the show.
Thank you. Thank you for having me.
The views, information, or opinions expressed during the My Legal Crunch podcast series or Skip the Conflict podcast series are solely those of the individuals involved and do not represent those of My Legal Crunch lawyers or Skip the Conflict or any affiliated media products, employees, or owners. My Legal Crunch lawyers and Skip the Conflict and their affiliates are not responsible for and do not verify for accuracy any of the information contained in this podcast series. This podcast may not be copied or distributed without express written approval from My Legal Crunch lawyers or Skip the Conflict. You may not edit, modify, or redistribute this podcast without content from My Legal Crunch lawyers or Skip the Conflict. My Legal Crunch lawyers and Skip the Conflict assume no legal liability for activities in connection with this podcast or for use of this podcast with any other website, computer, or listening device.